I think that one thing that we're all going to have to look at going forward is what are we going to do to get cases tried? As you all know, people need their day in court. And how in the world are we going to do that? I mean, that's one of the things that keeps me worried, and a lot of people on the bench and lawyers as well, is how are we going to do this? Because there's an enormous backlog of cases, But what are trials going to look like? Are they going to be more bench trials? Are we going to go with 6-person jury trials instead of 12-person jury trials? Because we're not going to come back into jury trials like it was before.
Hello and welcome to See You in Court, the podcast that informs you about the Georgia civil justice system, what it means to you, and how it protects individual rights. This podcast is a collaboration between the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Your hosts are robinfrazierclark and lestertate, who are both past presidents of the State Bar of Georgia and currently serve on the Board of Directors of the Georgia Civil Justice Foundation. And now this episode of See You in Court.
Good morning, friends and lovers of the law. Welcome to See You in Court. I am Robinfrazierclark, and with us here today, as usual, is my co-host, lestertate.
How you doing, Robin?
I'm doing fine. How are you?
Doing great. Still enjoying this podcast, born of coronavirus lockdown here.
Absolutely. And today we're taping this on a Friday, and tomorrow your Jackets play the dreaded Clemson.
That's right. They play Clemson, who's quarterbacked by a young man from Cartersville, Georgia. Was a Purple Hurricane. I watched him here in Cartersville play during high school, and has really just gotten better and better and better. So I am not hopeful of a Jacket win, but I am thinking that if the Atlanta Braves win tonight and go on to the World Series, that there will be at least one bright spot to the year 2020.
I agree. Well, today we're going to be talking about state court and state court in Georgia, and specifically, or more specifically, Fulton County State Court, the largest county in our state. And it's a pretty large court. We're going to talk about that. We're going to talk about the state court's jurisdiction and some issues that the state court of Fulton County is facing these days during the pandemic. And to help us understand these issues, we're thrilled to have with us the Honorable Susan Edlein, judge of the Fulton County State Court, here with us today. And she is going to be the next chief judge, in line to be next chief judge of Fulton County State Court. Judge Edlein, welcome to the show.
Thank you so much for having me. It's an honor to be on here and join you for your podcast.
We're very lucky to have you join us, and we know you're staying busy in Fulton County State Court, so thanks for taking out time to be with us today. Let me take a minute and just tell our listeners a little bit about Judge Edlein, because I've known her for a long time, and I knew she was impressive, but man, when I read her bio, it's amazing. So I want our listeners to appreciate all that she's done. Judge Edlein, as I said, she's a Fulton County State Court judge and has been on Fulton County State Court since 2008. In 2013, the Georgia Association for Women Lawyers awarded Judge Edlein its highest honor, the Kathleen Kessler Award, which is given to a female attorney who exhibits the highest degree of professionalism and dedication to service in the legal community. Again, in 2017, GAL, Georgia Association of Women Lawyers, awarded Judge Edlein with the Honorable Deborah Burns Community Volunteer Award in recognition of exceptional service to the greater community. The Atlanta Bar Association honored Judge Edlein as the recipient of its Professionalism Award in 2012. Before taking the bench, Judge Edlein was a litigation partner in Holland & Knight's Atlanta office, where she was co-chair of the National Real Estate Litigation Team and the Atlanta coordinator for the Women's Initiative Program, which is part of the firm's commitment to diversity. Judge Edlein is a member of the Board of Governors for the State Bar of Georgia and is the immediate past president of the Emory Inn of Court. She is vice president of the Lawyers Club of Atlanta. and Judge Edlein served as chair of the Judiciary Section of the State Bar of Georgia during 2011-2012, and serves as the Council of State Court Judges representative on the Chief Justice's Commission on Professionalism, where she chairs the Grants Committee. She's also a prior chair of the Atlanta Bar Judicial Section and is a current board member of the Litigation Section of the Atlanta Bar. Judge Edlein grew up here in Atlanta and attended Henderson High School in DeKalb County. She participated in the honors program at UNC Chapel Hill and graduated with a BA in political science. Judge Edlein then attended law school at University of Virginia, where she was a semifinalist in the William Minor Lyle Moot Court Competition and articles editor of the Journal of Law and Politics. Judge Edlein has been married to her husband Scott for 28 years and is the proud mother of 3 teenagers. She is an active volunteer in the community and with her children's schools, as well as the Temple, where she previously served on the Religious School Committee and as chair of its B'nai Mitzvah Subcommittee. Welcome, Judge Edlein. Very impressive resume, but I'm not surprised at all. But again, thank you.
And I'm going to add, she's a really good dancer too. Because I had the privilege of dancing with her at a state bar function, and even being the klutz that I am, I couldn't step on her feet. She was so able to move around the dance floor.
I will tell you, Lester, that my husband was very happy that someone else was willing to dance with me, because I love to dance and he does not so much. So thank you from Scott for that one.
Does that come from your time as being a Tar Heel? They all shag in North Carolina.
I was never quite so good at that one, but I will just say it continued on in undergrad, and I don't think it stopped.
And for those listeners who may be in the British Isles, let's emphasize that shag is a Southern dance, as opposed to some other meanings elsewhere that that word might be used for.
As soon as I said that, Lester, I realized I probably shouldn't have used that word, but we know it as a dance in America.
Exactly.
You're
and
right.
You can hold your beer with one hand while you do it if you're really good at it. So.
Judge Edlein, let's first, before we get into some substantive questions about your court, I wanted to ask you just a couple of questions about your career. And pretty large question: why did you want to be a lawyer?
You know, I asked myself. Somebody asked me that question a while ago, and I was like, it was just one of those things. I always grew up wanting to be a lawyer, and I'm never quite sure where it came from. I'm the only lawyer in my family. So I didn't grow up with parents or grandparents or anybody else. And matter of fact, I didn't know very many lawyers. But apparently this happened when I was 5 or 6. And my dad said to me, you know, Susie, if you like to argue so much, why don't you just become a lawyer? And I guess it just stuck in my head because my whole life I just knew I wanted to be a lawyer. And it never changed.
Yeah, you stuck with it.
That's great. So, right now we've got a confirmation hearing going on, for a U.S. Supreme Court justice where they talk about people's backgrounds, and we've got judicial elections. Mm-hmm. I guess they're all over where, candidates are talking about that. And you've had, I think, a very distinguished career at the bar before going on the bench. And I'm curious if you had to pinpoint one activity or experience or something that happened to you as a lawyer that you feel really best qualified you and helped you, that you rely on as a judge, what would that be?
Being a mom to 3 kids.
That's a great answer.
I say that partly in jest, but partly, just sometimes lawyers or parties get to squabbling and you're like, let's just get down to the issues here, right? And let's just focus on what the issues are. But, it's interesting. I loved being a lawyer. And I actually had someone once ask me, what's your dream job? At the time she asked me, I just made partner. My kids were 2, 4, and 6. I was happy to show up at work with the same color shoes on, right? And I was like, wow, my dream job. I was like, I would sure love to be a judge someday. I think that would be like the best job in the world. And she said, well, what are you doing to get there? And again, I was like, absolutely nothing. Like this is the first time I think I've ever vocalized that desire. And for me, I think being a judge is a good fit, because I have always been solution driven. And so for me, what I really enjoyed in the practice of law was really counseling my clients to try to find a goal. I wasn't litigation. I dealt with litigation, but some people thrive on getting in the courtroom and being a zealous advocate and winning. And, you know, my approach is if we get to court and we have to go through all that time and expense, even if you win, it may not be a win because it's going to take you years and it's going to cost you a lot of money, and many times. So I was always one for trying to reach a solution. And so I think that's one thing that as a judge, you know, I'm absolutely not an advocate anymore. I can't do that. But I do think it helps more giving parties an area where they can reach a resolution, whether it's through trial or otherwise.
I think it helps for a trial judge like you to have been in the shoes of a counselor representing real life people too.
Yeah, I mean, because one thing that and I've said this, I've been on the bench, gosh, now I think as much time as I was a lawyer practicing law. Wow, that's the first time I thought of it that way. But we're close to it. And I always said, I hope I don't forget what it's like to be a lawyer, to understand the demands put on you by trial calendars, by your clients, trying to juggle so many things, and understanding, you know, what it's like to try to schedule depositions, get cases ready for trial when you've got multiple cases and multiple clients. And, you know, that's something that I try to keep in mind when I'm, you know, working with lawyers in the many cases that we have here.
You left what I would call a very prominent law firm in Atlanta, Holland and Knight, obviously also a very large firm. You left a very large, prominent law firm to become a judge. You've told us that was because you thought judge would be your dream job. Now you're on the other side. You've been on the bench 12 years. Were you right? Is it your dream job?
Yeah, it still is. Every day I'm really thankful to be here and doing what I do. And I think that when I stop feeling that way, it's time for me to stop being a judge. Because I really enjoy doing this. And I know we're going to talk about it later, but I think particularly being in state court, you know, this may be somebody's only opportunity they're in the courtroom, whether they're there because they got a traffic ticket or they're there as a party or they're there as a juror, and, you know, letting them see what our justice system really looks like. I mean, I think that's really important. It's something I enjoy doing.
Very much struck me that you said you really loved being a lawyer, and you know, Robin and I know both have a lot of friends who decided to go on the bench instead of remain at the bar, and so many of them say, "Oh yeah, I wanted to go on the bench because I just hated being a lawyer. You know, I didn't like it." And I think that really, to me, seems like it gives you a very good outlook on what you're doing there.
I will say that I loved being a lawyer, but I hated billable hours. So it's really nice not to have those anymore.
Yeah, that's why one of the reasons I do what I do. I haven't billed an hour in over 20-something years. I don't know how long it's been, but a long time. Judge Edlein, let's talk a little bit. You kind of got into this topic about Fulton, about state court, and specifically your court, Fulton County State Court. Our listeners are both lawyers, but also just public. And the mission of this podcast is to educate the public about the Georgia civil justice system. And I have heard many people, and I think it's right, talk about that state court is the place where most citizens of Georgia may have their only contact with court. Can you tell us a little bit about what the jurisdiction is of your court, and if that's a true statement and why?
We definitely have a lot of people coming into state court, and here's one reason why, I think, because state court handles misdemeanor cases. So for those, our listeners who are out there, so that's anything up to 12 months in jail and up to $1,000 fine. We also handle in Fulton County, we have a lot of traffic tickets that people may have. So if you're thinking about the misdemeanor cases that we try, it could be everything from criminal trespass to, the more serious cases, the DUI cases and domestic violence ones as well. And also these may be a lot of the types of cases that people might be a part of. For example, we have a lot of folks who may be involved in car accidents. We see a lot of those kinds of cases. Sometimes there's a lot of collection matters that might be filed in state court. What kinds of cases do we have? We can handle all sorts of civil cases. Like I mentioned, anything from a collection case to a business dispute, medical malpractice case. We don't do domestic, so divorces, child custody, and anything when somebody needs like equitable relief. So think people like to think maybe trade secrets. So you're trying to stop somebody from stealing your trade secret, something like that. That equitable relief is in superior court, and the felony, the serious criminal cases are also superior court. But we handle the rest of those, and a lot of, I think in Fulton, we have a large civil practice in state court, in part because we don't have the same heavy criminal load and domestic caseload that they do in superior court.
I'd just note, sort of for our listeners too, that not every county in Georgia has a state court. For example, Bartow County, where my principal office is, doesn't have a state court. Polk County doesn't have a state court. Paulding County doesn't have a state court. And there's no real rhyme or reason to it as far as, Metro Atlanta has state courts and smaller areas don't, because there's some very small counties that have state courts and some of them even have part-time judges, don't they?
Yes, they do. Pardon me. Go ahead.
I was going to say Fulton is one of the, I guess, one of, if not the biggest state court in the state of Georgia.
I think so. We've got, in Fulton County, we have 10 state court judges, full-time state court judges, and we've also got 20 superior court judges here in Fulton. So I think we have the most sort of full-time trial court judges of any county in the state.
And again, you never have to hear a divorce, and you never send anybody to the penitentiary because you don't have felony jurisdiction and you don't have domestic jurisdiction.
Yeah, we don't have the ones over the domestic cases. That's right.
I file a lot of lawsuits, and almost always, and a lot in Fulton County, but almost always in state court is my preference. I have come. My practice is just a general personal injury practice of all types of cases, but I have found that state court judges tend to be more of an expert on the types of cases I have. I ventured out into superior court once and I regretted it, and I'll never do that again unless there's an equitable issue. I was once sent to superior court by a judge, but do you feel like because of what you see and how many cases you handle, that you've developed that expertise over certain types of cases?
I think so. I think part of it's a familiarity with trying the same type of case on a regular basis. Like I was looking back, for example, I use car accidents because honestly, those are the cases that go to trial more than any others in this, and I'm talking the civil arena here. I think every case that I had in 2019, or maybe it was 2018, that went to a jury trial was an automobile collision case. And so you get to know how to do those very well. And just so everyone's clear, there's a lot of work that gets done by the lawyers and the judges before a case even makes it to a jury trial. Because and there's lots and lots of cases. The vast majority of the cases, I read a statistic once that over 90% of the cases settle or resolve in some way before they go to a jury. So I feel pretty comfortable with the law and how to run a jury trial or the pretrial of an automobile collision. Just because we've done so many of them, as an example.
Mm-hmm. Can you give us an idea of how many cases you preside over at any one time? Y'all have those stats? I don't even know.
It's rough. I think as of right now, I think I've got somewhere around 2,000-ish cases. And about 700 or 800 of those are civil, and then the rest are criminal.
That's pretty that's amazing to me.
It's a lot of cases.
That's a lot. Yeah.
But some require a lot more time and energy than others do. A lot of those cases may be, for example, a collection on a medical bill that someone didn't pay, or a credit card bill, and some may be really complicated, in-depth cases where I know the lawyers and the case number and all of that quite well. So it runs the gamut.
So what's happening with with the COVID? We haven't had a jury trial in Georgia, I guess, since about March, if I remember correctly.
Yeah.
And I have a practice that's has a lot of automobile claims, a lot of tort claims, but I do some criminal defense and other stuff as well. And so I've settled some of those claims, but people always joke about folks settling on the courthouse steps, and I tell them that that's when everybody knows the most about what their case is, and two, it's the last exit before you're going to let somebody else decide it instead of you. And so I've settled some cases, but I don't think at the pace I was settling them when they were on trial calendars. And everybody knows we're going to either have to go try this case or we're going to have to resolve it right now. And so I'm wondering, has your civil docket really backed up at this point? Are you getting a lot more cases, or did the COVID situation slow the inflow of cases to where it's sort of held steady?
I think it slowed some, and I just talked to our chief deputy clerk in the civil division. He said last month was the heaviest month of civil filing that we've had in a long time. So even though it may have slowed for a while, I think that it's opening back up again. I know lawyers have been continuing to get cases ready for trial and everything they could do. So yeah, I mean, as a judge, one of the biggest shifts is managing 2,000 cases. Because I think it's my job as a judge to make sure that cases are tried or placed on a trial calendar within a reasonable amount of time. So therefore, I'm a big fan of putting scheduling orders in place so people have deadlines and know when they're going to be on a calendar. I think it's good for lawyers to plan and know what it's going to look like and when they're expected to have certain things done. And that COVID has kind of thrown all that up in the air. I mean, you could still have some deadlines for, trying to get discovery done and filing of dispositive motions, because those are the kinds of things that we can continue to move on until we get jury trials up and running again for state court or for civil cases in particular.
Talking about hearings that you can conduct now, I assume you're doing them by Zoom or some other platform. And I noticed that you have a YouTube channel. Are you broadcasting hearings by YouTube?
I do.
Can you tell us a little bit about that?
Sure.
And I kind of like to know about how the judges came up with that idea. It's a great idea, but
I can't take credit for it. I don't know who came up with it. We do it here in Fulton County on the Zoom platform. And I just want to give a big kudos to all of the IT professionals, not only in Fulton County court system, but everywhere, who have just been invaluable during this in helping so many different industries, including the courts, get up and running, because we didn't have that technology beginning of March, at least not as readily available.
I didn't know about it.
I don't think I had ever used one really. But it's, so I like using Zoom. The only thing that's weird is I don't do a very good job like looking in the camera, because I'm used to looking at lawyers and people when I talk to them, so that, trying to make that eye contact. When it's weird, you get your Brady Bunch screen up here and you're looking off at one corner and somebody else is looking elsewhere. But that's my only downside with it. But it's important for the public to be able to see what's happening in the courts. And I think it's an essential part of how our justice system works, is that it is open, that people can come in and observe it. So we do have a YouTube channel, and which broadcasts I broadcast it live while we're doing the hearing, so that people can see it and know what's going on. And I know some people do it on Facebook Live, and there's different courts and whatever people have their preferences. But here in Fulton County, I think all the judges have YouTube channels. All of the hearings that are going on in the jail are being live broadcast on YouTube channels as well.
So
that's really neat.
So, it's interesting to me because, again, in my practice, I'm on the side having the burden of proof in all my civil cases, virtually, where I'm representing somebody that's been injured or, has a medical malpractice claim or whatever. And then in the criminal stuff that I do, I'm on the side that's defending against that, defending against the party with the burden of proof. And I've sort of noticed that when you talk about jury trials, and particularly if you talk about having a virtual jury trial of some form or fashion, where the jurors aren't there, whatever, the party that does not have the burden of proof, the defense lawyers in civil cases and the criminal defense lawyers are all like, oh no, we could just never do that, because you couldn't tell if the jury was paying attention, or you couldn't tell what else they might be looking up on their computer or something like that. And so I've sort of identified that there's sort of a bias amongst those folks who have the burden of proof of saying, yeah, we need to kind of figure this thing out, and move forward where we can do those virtually if we need to. And the other side sort of, no, I don't think we'll ever be able to do that. What's your view on it?
Well, I don't think I necessarily agree that it's only the side that doesn't have the burden of proof. I think I've heard concerns from both sides of the V, whether they be in state or, whether it's a civil or a criminal case. I am not quite sure how we would do a fully virtual jury trial. I know that there's some states, I think, that have tried it. I'm not sure if it's been fully virtual or not. And I've sort of read some blurbs about it. There's a lot of challenges. I've heard issues as far as, are the jurors paying attention? It is a weird thing, and I feel bad for jurors who come in. As adults, when was the last time you had to sit down and you couldn't take a break, you couldn't pull out your phone, you couldn't do whatever you needed to do, just sit there and listen for hours at a time? And that is not something that we are used to doing anymore. So I think it's a real concern to make sure everybody's paying attention, especially if it's a virtual environment. I still am not sure how they would do that with jurors, to be quite honest. Have jurors in a different location. Now, maybe if it's I'm going to use the term safe room, and that's not the right thing, but if it is some room by themselves in the courthouse and there's a camera in there and a TV, maybe. But if somebody's just at home, watching this on their iPad, I'm not sure. I don't know how that would work, to be quite honest with you.
Yeah, I'm not a proponent of it. I'll say that. I don't think it would be good. The other thing, besides making sure jurors are paying attention, and by the way, it is sort of a prison sentence to sit as a juror live in person at trial and listen to a medical malpractice case for 2 weeks. I feel for them. But the other thing that bothers me about attempting a virtual jury trial would be access to the internet, access to the right device, access to a quiet place for 8 hours a day. The access, and I'm afraid if we said, okay, every juror who has access to all these things, you can be on the jury, and the people who don't, sorry, you're excused. I think that would skew our jury pool, and honestly, not in favor of my client.
I think this is a fascinating thing, because Robin, of course, is immediately stuck the pin in my balloon theory there. That plaintiffs' lawyers didn't want the. But maybe we need to have another podcast to get a lawyer and a civil defense lawyer, civil plaintiff. We have a debate over whether we could have a civil, where we could have a virtual jury trial. Because I think about,
I'm not sure you're going to find anyone arguing in front of it who's in favor of it, Lester, who's a trial lawyer.
Interesting. Because I as I'm sitting here listening to this, and of course I'm being a little bit of a devil's advocate as well, but I'm thinking, like, because I know people who have tried bench trials tried bench trials virtually. And I know, given your distinguished career at the bar, Susan, trial lawyers always worry if the judge is listening or not, or the judge has gone back and Googled, something about their client or about their case, whatever. Yeah. And they've got 100%. When they're the finder of fact, when you sit as a finder of fact, you've got the 100% control, over the outcome of that. And I also think that at some point, for the reasons that I said before, we just kind of got to start moving forward with some jury trials, because it'll push some things toward settlement.
I think that you bring up a couple of points. One is, I mentioned earlier, I have standing orders, and I've still been doing standing orders in all my cases, and I include in there the paragraph that if the parties are willing to do it, that I'm willing to have a bench trial with the consent of the parties. I think it's pretty easy if you were talking about something that is, a breach of contract case or involves some more legal kind of issues versus, the types of case I know that Robin handles when people have suffered, injuries, very often catastrophic injuries. And it's not easy to put a particular dollar value on it, as it is like if it's a breach of contract case and you're like, here are my invoices, you owe me $20,000, that kind of thing. But I think that one thing that we're all going to have to look at going forward is, what are we going to do to get cases tried? As you all know, people need their day in court, and how in the world are we going to? That's one of the things that keeps me worried, and a lot of people on the bench and lawyers as well, is how are we going to do this? Because there's an enormous backlog of cases. It's a lot of it, I've always sent cases to mediation. I'm continuing to do that. I know some people have had success with virtual mediations, and I don't know if you all have tried those or not, but I know that those are continuing. A lot of cases get resolved that way, even if it's not during the mediation. It might be thereafter, because you may have been able to talk out some issues. But what are trials going to look like? Are they going to be more bench trials? Are we going to go with 6-person jury trials instead of 12-person jury trials? Because we're not going to come back into jury trials like it was before. The Chief Justice just issued a new order that are allowing jury trials to resume again in the state, provided that safeguards are in place, at the courthouse to protect the safety of everyone involved. But it's not going to be like it used to be. We're not going to call 300, 400 jurors down here and set them in the jury assembly room in the Fulton County Courthouse. And we're going to be, go ahead.
Let me ask, I agree. And let me ask you about that. Because I know, for example, in DeKalb County State Court, Judge Mike Jacobs has said they had some entity come in and actually measure out the courtroom and figure out what's the maximum capacity 6 feet apart. And it was only, they're tiny courtrooms in DeKalb County, only about 15 people max with proper social distancing. So Judge Jacobs was saying, we're not going back to a in-person jury trial for a long time because we can't comply with the safety. And I'm wondering, has your courtroom had that kind of investigation of it to see what the capacity is and how you could do one in your courtroom?
Sure, we have. And, actually we were, one of the things I've been spending a lot of time during this COVID is working with our other justice partners to try to look at the procedures and process that we've used, particularly in criminal cases, in changing that, and how can we go forward. And we just have the technology in place now to allow us to have some people participating virtually and some people participating in the courtroom, because it required pretty big technology upgrade for us to have multiple computers at every space. And but so we are going to have that available here in the Fulton County Courthouse, within the next few months, to allow us to do more, I call them hybrid proceedings. But yeah, I think I can only fit 15, 16 people in the gallery where, where people used to come in and watch the courtroom. So it could be that's where we put the jurors. It could be we have the jurors in plexiglass boxes in the jury box. I don't know exactly what that's going to look like. I know that there is a team of folks here in Fulton County who are looking at how are we going to do jury trials? Where are we going to do them? We're going to, start it slowly and figure out what that's going to be. But, safety is a huge concern for everybody involved. People, either if you get called down for jury duty, or you're a party or a witness or a lawyer or the judge, it's a concern. And so right now we are looking at ways to make it so that people can come down, or they don't have to be here, or they can participate virtually. And the ability to still see what's happening in the courtroom.
One thing that I have repeatedly said I hope COVID kills, which is a relic of rural trial practice, is the calendar call. Truthfully, in Fulton and DeKalb, especially, they hadn't really done that in a long time. But every case I have in some place like Bartow or Whitfield or whatever, they want to have a calendar call where every lawyer, that's got a case down there comes in, and it's, it can be more easily done by emails and, telephone calls and whatnot now. But a lot of the stuff that you're talking about with the jury trials, I think people don't realize that, if you got a 12-person jury and you got one person on each side of a case, and you've got one lawyer on each side of a case, you're up to 16 folks right there. You've got a judge takes you to 17, a court reporter that takes you to 18, a clerk that takes you to 19, even if you just have one bailiff, in the whole thing, it's 20 people or it's nothing, in that situation. And that's a lot of folks in architecture that's really been built for everybody to sit on top of one another. And that's pretty much true in every courtroom in the state that I've been in.
Yeah, you're absolutely right. It's a minimum of 20 people who would be in there for a 12-person jury trial. Here in Fulton, we do have some larger courtrooms that are bigger than the one that I've got, but we don't have that many of them. So, and some would be available only for civil trials and couldn't handle criminal cases. We have to have holding cells, especially if someone's in custody. So there are those limitations as well. But I mean, Lester, you're absolutely right. We have to make sure that we've got ways to maintain social distancing in the courtroom. And, maybe it's the jury sits back and everybody turns their chairs around and you face, where it used to be the audience watching. One of the nice things that we just did is we added TV screens. You guys haven't been down here to see this yet, but we've got big TV screens that are going to be live streaming what's going on in the courtroom out into the hallway. So if people want to watch it, they don't necessarily have to come into the courtroom. They can stay out in the hallway where there's some more room to watch it.
That's a good idea.
So switching off COVID for just a minute, with Superior Court judges who do adoptions and state court judges don't get that. If you ever ask a Superior Court judge, what's your favorite thing to do? They say, oh, I love doing adoptions, and they bring the babies in and whatnot. But as a state court judge, what would you say is your favorite thing to do, the thing you look forward to doing?
Oh, goodness. One of the cool things about being a judge is you get to marry people. I love weddings. That's a neat thing to get to do. Favorite thing, I work with DUI court, and I've been doing that for 7, 8 years. I'm not even sure how long it's been now. And so that is a really meaningful thing in my role as a judge that I really enjoy doing. And DUI court is an accountability court. It's for people who have been convicted of 2 or more DUIs, and it is a treatment court. So it gives those people who fall within, who come into the court, it gives them counseling, both individual and group counseling, requires abstinence from all drugs or alcohol. And they get to come see me. We've been doing it via Zoom since they get to see me or Judge Wesley Taylor, who's the other judge who does DUI court, every other week when they start off. So you get to know people in the program, you get to celebrate their successes, and and people slip up occasionally. And so you, as the judge, have to deal with that and hold them accountable for their actions, but move forward. So
that's where being a teenage mom really comes in handy, I'll bet. So
that is true. That is true.
That's an interesting, the DUI court that you preside over is really, I think, innovative, creative. It's a recognition that these folks have broken the law, that there's but there's a underlying problem making them break the law or causing them to break the law. And so maybe they don't need the harsh treatment of jail or something like that, but some other way to deal with what they're doing. I think it's a great idea.
Yeah, and they're nationwide now. Ours has been around since 2007. Judge Susan Edlein started it and was one of the first ones in the state. They work. Accountability courts work. We have them in Fulton County for DUI, drug court. There's a veterans court that helps folks who have served our country, and many of whom may have developed an addiction of some kind afterwards. Or as a result of that, and gives them, additional counseling and resources and mentors. We also have some in juvenile court, and there's also a mental health court, both felony and misdemeanor here in the state. And they're not easy. Some people would rather go to jail for 60, 90, 120 days than have to do all of the work that's required of them as part of an accountability court program. I think it's a lot harder. Not that I want to spend time in jail, but.
I've been involved in politics or practicing law for almost 40 years now, and I can tell you that the unbroken, there was particularly a period here in Georgia back in the late 80s and through the 90s where every year it seemed like the General Assembly's main theme was we want to toughen DUI laws. So there was sort of this unending addition of punishments and lowering blood alcohol content, stuff like that. But as far as I know, there was never anything to actually treat the underlying problem like the DUI court that you're talking about before Judge Forsling and some other judges in other jurisdictions started running the DUI court. Is that correct?
Pardon? I missed that last part.
I said, is that correct? I mean, that wasn't something that was going on elsewhere in Georgia. I mean, Fulton was sort of a pioneer in that regard, were they not?
Yeah, we were one of the earliest ones. I think actually the earliest one was up in Athens, Clark County. I think that was the first one in the state, but we were a pretty early adopter. You're absolutely right, to DUI courts.
I think also Judge Deal, he's somewhere in North Georgia, Hall County or somewhere up there. Governor Deal's son, who's a judge, started not DUI, but I think it was a mental health court.
Yeah, he runs a drug court, I know.
Drug court.
And actually, Governor Deal, I think, has spoke on his support of those from going and watching his son's participants' graduations and how impactful that was.
Has having to do it over Zoom, doing the DUI court, has that had an impact, or are they still being held accountable and showing up and doing all the things that you require them to do?
Yeah, and like everybody else, I appreciate the flexibility of the participants, because now they have to do all their counseling sessions via Zoom hearings, and come talk to the judge via Zoom hearing. I guess it's easier because you don't have to travel someplace sometimes, but it's not the same as being in person, but I think everybody's just making the best of it that we can.
Well, let's talk about juries sort of just in normal times. We've had a little break from that, but you were talking about that, and I know you probably have DUI jury trials a lot. You have a lot of car wrecks, a lot of stuff. It sounds like revolves around automobiles and driving them or wrecking them or whatever else. But do juries surprise you with the verdicts they come back with? Have you experienced that?
Rarely. Usually I think I'm pretty, I like to sort of, as I'm listening to it and I'm listening to closing arguments, especially in civil cases, when it's just sort of, here's the, folks are asking for money, it's really, that's the relief they get in state court from a jury. So I usually have my range of where I think the jury is going to come within, and normally I'm pretty good at pegging where that's going to be. I may not be right on, but I'm usually, sort of within that range. I think I've been surprised only once or twice, like that it's outside of where I thought it was the range where I thought it might come in.
We talked about if we ever had a virtual jury trial being concerned jurors not paying attention, but let's go back to our normal in-person, non-COVID era jury trial. Have you ever had to, on your own, kick off a juror for not paying attention or doing something, looking at their phone or something like that?
I will usually call somebody on it if their phone, or I'll get it doesn't happen very often. What you see more often is sometimes lawyers are a little long-winded, and instead of making their point once, they're making it 4 times. I'm just like, because I will say this, although people may not be thrilled to come down to the courthouse, and they may not be very excited if they're selected as a juror, I think almost every single person that I have had who has served as a juror has taken it really, really seriously, listened, and worked the best they could to come up with what they think is the right verdict. I firmly believe that, and that 99.99% of the time. But sometimes, what were you going to say?
I was going to say, so one of the things that as you're talking about long-winded lawyers, which I certainly have experienced that and have been guilty of it myself, I'm sure on numerous occasions. A lot of the judge's role at the end of the case is, and I'm saying this really for our listeners who aren't lawyers, is to give the charge, to tell the jury what the charge is, and the judge doesn't really just get to make that up. There's some guidelines. You get to decide which charges to give and which not to, but there's some pretty standard language about that. And so, what's your approach to the jury charge? And do you feel like jurors? Do you feel like it really makes a difference? We had a judge here in Bartow County years ago, has passed away now, but he said, I think sometimes if I just told the jury, go do the right thing, they'd come back with the same verdict that they come back with after I give them this charge. And so I'm kind of curious to know what your take has been on that.
Well, I will answer that because I actually like jury charge issues, but which makes me weird, I think. I think that's just my inner geek coming out there. But back to Robin's point, so I have people fall asleep sometimes after lunch. It's long-winded. So if you see me start to throw books on my table or slamming drawers around, that I am trying to get a juror to wake up without necessarily embarrassing them too much. So I'll get my deputy up there to, or else I'll give everybody a stretch break. We can all stand up and stretch to make sure we're all doing okay.
Sometimes I like it when my jurors sleep.
I guess it depends on what part of the case it is.
It does.
Right.
Yeah, that's my job to make sure they're not sleeping. But to the issue of jury charges, okay, first of all, I think jury charges are really hard to understand. Secondly, they can be.
Me too.
They can be. If anybody out there has a really good proximate cause charge that I'm talking to the lawyers here, that they want to give me that makes sense, because one I think we have is hard for me with legal training to sort of get my head around sometimes if I really sit down and look at it. But there's a project going on right now for trying to rewrite some of the jury charges in more readily understandable conversational language without changing, the underlying meaning. But I give jurors a copy of the charge to have with them in the jury room, because you've got folks who don't have legal training, and if we are expecting them, especially in a 2-week-long complicated medical malpractice trial with multiple experts, and each of one is highly qualified and they're taking opposite positions about whether something was done correctly or incorrectly. And we're asking folks who are not trained in, for example, medicine or law to come in and make these decisions. I think it's important for them to be able to go back and look at what the law is. So I always give my jurors the charge to have with them in the jury room. I also charge them on what the law is before closing arguments, because I think it's helpful for the jurors to hear, this is the law that you have to apply before the lawyers come in and argue, my client should win for these reasons.
That's interesting, because I think in a lot of states they do it that way. I've never, I've tried about 100 jury trials. I've never seen it done that way in Georgia, and I always end up arguing, telling them what the charge is going to be instead of them already having heard it, which seems to be the way we do it. Seems to put the cart before the horse a little bit.
What about, would you ever charge the jury before the first witness? So as they hear the testimony, they have the law in their mind.
That's a good idea. They get some of it before that about credibility. They get a little bit. I have started giving more substantive charge in the beginning. And I would consider it, I think I did it in a medical malpractice case. I don't think you necessarily need it for a car accident.
Yeah, that's true.
But I think for some of the cases that are maybe a little bit more complicated as far as legal issues, I think it's a good idea. It doesn't hurt to have that in your mind about, I know that me as a listener, I want to know, what are the important things that I'm supposed to be listening for versus what's a red herring. So yeah, I think it's a good idea.
Well, we may do that. I may do that if I ever get back in the courtroom trying a case. I was going
to get to try a jury trial again.
Yeah, I was going to tell you the last trial that I tried was last year, because I didn't try one. I don't think I tried one before COVID this year. And my jury was out. You're talking about that jurors take their oath very seriously and work very hard to reach the right result. And I agree. My jury was out and was in DeKalb. They were out for a week. And I'm praying not for a hung jury, because that's probably one of the worst things that can happen to a plaintiff and a plaintiff's attorney is a hung jury. So I'm praying not for a hung jury. But they came back with a verdict after a week. I felt like that was the hardest working jury I've ever had. And I've tried not as many as Lester, but pretty close, so almost 100. So I do believe they take that oath very, very seriously, which is, the way it should be. And I think it's a hallmark of our civil justice system that they do.
Mm-hmm. I agree with that.
So with, you talked about trying a lot of car wreck cases. And, one of the games that sort of gets played in car wreck cases, particularly gets played in all tort cases, particularly in car wreck cases, is the jury's never told that there's car insurance, even though if they stop to think about it, they probably know that. Do you think most jurors see through that, or do you think do you think their verdicts would be changed if the law were just, you tell them it's State Farm or Allstate or whoever that's going to pay the verdict?
I actually tell my jurors that they should not consider anything that isn't part of the evidence. And I call this my don't consider the issue of insurance charge. And It's a generic charge. It doesn't necessarily say you should consider insurance, but it's something to the effect of, you have heard all the evidence in the case, and you should not concern yourselves whether any third party is or is not paying all or any part of, the damages or judgment, because then it covers, because not only is it car insurance, but you also get the question about, is somebody's injuries covered by health insurance, and that doesn't come in either, or disability insurance, and that doesn't come in either. So I actually think I got this charge from Judge Wesley Taylor. And I have started I've been giving that charge for a few years now.
Does it eliminate their question? Because the first question they always have is there insurance?
I got that question almost every single trial, almost every single case. And I have rarely, if ever, have I gotten it once I started giving that charge.
That's interesting.
So I'll be happy to share it with you guys.
I would like to have it. It fixes a problem, because the first question out of the box is,
and you can't blame
what's
them.
their insurance? Yeah, that's what they're looking for.
So one other sort of out of the blue question here, because I've had this happen some before. Jurors sometimes have questions, and I remember the first case I was trying where I was defending a felony case down in Clayton County, and a juror says, "Can we ask a question?" And the judge said, "Only if the lawyers agree." Well, by golly, I popped up first and said, "That's fine with me, Judge." And the poor prosecutor, what was he going to say? So the juror got to ask his question. And, now we even have some judges that sort of invite questions, from the jurors. And just like you talk about, the juror needs to kind of know what the law is. They're making the decision. And I think in a lot of states, they do have some, right to ask questions. What's your view on that?
I think if you've got procedures in place to do it, I think it's fine. But here's the issue. Lawyers may bring up or not bring up certain things for a strategic reason. And I get that. But at the same time, if I'm a juror and I've got a major question about it, but sometimes it's just a clarification question. Like, I didn't understand what you said. Can you explain this answer? So the way, and I know some judges here in Fulton County, but state and superior court have done this. And the way that I understand it works, and I sat in on one of the trials once, is that when a witness is done testifying, if the jurors have questions, they can write them down on a sheet of paper. Then they take a break. The judge reviews those questions with the lawyers, may end up rephrasing the question, and then the judge puts the question to the witness, and may rephrase it somewhat. So then that question is then asked of that witness, and not every question gets asked. And I think that's probably a pretty good idea.
I guess I would lean toward the side of let them ask questions in my cases, civil cases, because I want to fill up any hole. If I've left a hole in my evidence that the juror is worried about, I'd like to know what they're thinking in advance. That would be nice. But I do see it having constitutional implications in a felony case.
I don't think that they've done it in criminal cases. Well, I don't know that for sure.
I know they did it in one.
Oh, did they? Okay.
Ex McIver is coming up. We'll see. We'll see if that's going to.
Right.
That's on appeal, and it was Judge McBurney, and there were a lot of questions.
I forgot about that. You were absolutely
made the trial really long too, but I think that's going to be one of their appellate issues. I think because I'm pretty ssure Bruce Harvey objected to any question from the jury.
Yeah.
So we'll have it. We'll have a case on it, I think.
Yeah, I think the other thing, I think the one thing that I would worry about that a little bit, and in the case that I had, we had where the juror wants to ask, and the judge just lets him ask the question, and he did, and the one jury charge that I think jurors probably pay less attention to than anything else is the one about. Now, if I, as the judge, have done anything that would imply that I was for one side or the other, you need to ignore that because I have no interest in this case. And I just think jurors don't believe that. They think a judge, we pick judges because they're smart, they're learned, and they think they formed an opinion one way or another. And they and you know, I've heard jurors before say, oh, well, when the judge jumped on that other lawyer, when the judge said this to you, you know, and so I think, you know, if I were going to do that, I'd rather the clerk read the question or something where it's not, you know, cloaked in judicial authority that might be interpreted one way or another, or might be subject to interpretation either way, you know, depending on who the juror is.
That's a good point. Yeah, that is one thing that, you know, I as a judge have to be really careful about is I know the jurors are, you know, watching my facial expressions and, you know, how I'm responding to the lawyers, and, you know, that I've got to be very aware of how I, not only the words I'm saying, but things I'm not saying.
And I think sometimes too that, yeah, I mean, I think the juror expectation about that's real. You know, we last night the Braves had a 22-year-old pitcher go up against a future Hall of Famer, and I think any judge, I mean, any umpire that follows baseball would say, "Wow, this kid really did well." Does that mean he gives him more balls and strikes? No, you know, you're just in a different function, you know, about that, you know, one way or another. And but I think. You know, it's got to be a problem for a judge. Thankfully, I've not. Thankfully, both for me and any litigants that would have had to appear before me, I've never been a judge, so I haven't had to worry about it.
Well, also judges are people too. You can't absolutely check all of your emotions at your chamber's door when you go into the bench, which I know is hard. You're trying to be like that, but I'm sure there are some people that just get under anybody's skin, no matter how judicial you are. There
are times when I'm like, it's time for me to take a break. And
exactly. I can imagine. Yeah. I need to get off the bench before I do something.
I know too, Judge, we had
I will say that there was that the judge who I took his seat when he moved to Superior Court, he left me a note, says, "Keep your mouth shut." Like, and that note from 12 years ago on the yellow sticky is still sitting right there. I look at it.
I can go you one up on that. I was a judge for a law school mock trial competition over at the Russell Building, one time, and they wanted me to be the judge, in the final thing. And I go up on the judge's bench, which to me too, even having been in the courtroom as much as I have, it was really scary. I got to tell you, I'm like, I don't know what I'm doing up here, but there was a marble plaque. I mean, like a marble engraved like a tombstone or something sitting there, and it said KYDMS, and I went, what does that mean? And then all of a sudden it hit me, keep your damn mouth shut. And I followed that advice even with the law students.
That's good. I think I need to upgrade my yellow sticky to that. Although it served me well for 12 years. So.
Well, it was. I will tell on who it was. I was in Judge Tom Thrash's courtroom, so he might can enlighten you on that.
Well, Judge Edlein, it's been wonderful having you. Probably need to let you get back to work, but we can't thank you enough. And at the end of our show, every time we ask our guests, what is their definition or their notion or understanding of justice? And we want to ask you that and have you share your ideas about that. How do you define justice?
That is not an easy question to answer, because it's kind of like just one of those things. It's ultimately, you want to treat people the way that you would want to be treated if your loved one was down in front of a judge or a jury. There's a piece of paper that I've had since I graduated from law school. And this is when I went to law school, this was engraved in one of the buildings. And it said that those alone may be servants of the law who labor with learning, courage, and devotion to preserve liberty and promote justice. And that has just sort of stayed with me ever since. And in promoting justice is, you want people to leave the courthouse, whether they won or lost, to know that they were treated fairly and that they were heard. And sometimes that's all I can do is let people be heard, because the law may be absolutely against them. But if people think that they that they understand what happened. And I think understanding is a big part of it, because the law can be confusing to a lot of people, especially those who may not be educated in all aspects of the law, and that's hard. And so I think part of what justice is explaining to people what has happened and why. And I think oftentimes if people know that they had a chance to come in, say what they needed to say, and sort of understand what happened to them, whether it's a civil case or a criminal case, that I think that's a really important part of, for me, especially as a judge, to do that. And, obviously it goes without saying that everyone, no matter your gender, age, sexual orientation, race, national origin, none of that should play any part of it.
Well, you have done, thank you for being with us today. And I will have to say, as you read that, I truly believe you embody that and the dealings and the cases I've had in front of you. So not only thank you for appearing today, but thank you for what you do for the citizens of the state of Georgia.
That's right. Thank you, Judge Edlein, and we appreciate you and appreciate your work on the bench, and you make us proud being on the bench.
Well, thank you. That means a lot, and this is a lot of fun. I feel like I sit here and talk to you guys for another couple of hours. So
we'll have you back on for part 2.
Really, honestly, thank you all so much. This has been great talking to you, and I really appreciate the opportunity to do that. And it truly, as I said earlier, it is an honor to be in this position, and I'm lucky to do what I do.
So every week, or every podcast episode that we do, we always try to have a news article from the last week or two that we want to share with our listeners that highlights the things that are going on, current events. It's sort of like current events when you were in middle school that we talk about. So I've got my current event. I'm going to get my extra credit today for my current event.
I can't wait.
So this comes from this last week, Thursday of this last week. The Iowa Supreme Court on Wednesday ruled that 74,000 absentee ballot requests submitted by voters in 3 Iowa counties will remain invalid because of technical problems with the paperwork, the Iowa Supreme Court ruled on Wednesday. I bring this article up not because I agree or disagree with this ruling. I haven't read the ruling one way or another, but because this is an example of one of a spate of rulings in both state and federal courts that are taking place throughout the United States right now in the run-up to the 2020 general election. And, our electoral system is sometimes called an adversarial system, but it's certainly a competitive system, just like when people go into court, one side with their case, the other side defending against it. And I think this case, though, emphasizes, because you've got 74,000 people out there who've requested absentee ballots, that will have to either go vote in person or will have to re-request it because of a technical problem there. What an important role that our courts, and particularly our state courts, because you hear a lot about litigation in federal court over voting rights and whatnot, but each of our 50 states have their own rules and regulations about voting. Those have to be interpreted. And Robin, as you know, this is just one of probably 5 or 10 rulings that I could have read or could have made reference to today. But I think it's very important that we have a judiciary and have judges who are both nonpartisan, not aligned with one side or another, to go in there and look at the law, look at what happened, and make a decision about that. Because when you talk about voting, it's one of the most precious rights that we as individuals can have. I urge folks to go out and exercise that right to vote. We're already in the early voting era here in Georgia before the 2020 general election. But I think it's great that we have courts to make these decisions. And I hope that all those courts take them seriously and do not have judges or justices on there who say, well, I'd really like it to be this way or that way. We need umpires and judges that call balls and strikes.
Absolutely. And I know there are numerous lawsuits pending right now over various forms of basically voter suppression. I just was listening to a podcast that I like, Stay Tuned with Preet Bharara, and he had a guest on talking about who represents a lot of entities in these lawsuits, talking about voter suppression. And you make a good point that voter suppression can happen, and if there weren't a court to stop it, what would we do? I mean, we would be stuck without any sort of justice or ability to vote, ability to express our opinion on something if there weren't a court where we could go and file a lawsuit. People sometimes are quick to denigrate courts and filing lawsuits, but they need to realize, those who would do that need to realize it's the only thing protecting your rights. Thank goodness we have a court to be able to do that.
You know, I tell people all the time, they talk about a lawsuit, and a lawsuit is just to the judicial system what a bill is in the legislative system. It's the vehicle that you bring something forward to the body to get a decision on one way or another. And I think we're seeing the vital role that some of those suits are playing here as it pertains to our elections.
My law-related news is about Justice Ruth Bader Ginsburg, who passed last month, as we all know. She was one of my personal heroes. And the news is that Brooklyn in New York is creating a statue in her honor. They'd already had this in the works, actually, but they have a statue that's almost ready to be placed, and it's going to be placed outside of a city building in Brooklyn. And it has a very likeness of her in her robe with one of her dissent collars on. It's going to be in bronze, and she's up on two steps. And the artist who created this statue said, with the two steps on its large base representing the Supreme Court and the climb she made to get there, the work is designed to provide the public with an opportunity to stand at her side and gain inspiration from her journey fighting for equal rights. That's what the artist said about it. So I can't wait to see. It's going to be dedicated in March 2021 during Women's History Month. So I'm excited about that. And there are not many statues that honor women anywhere in America. It's mainly men. So I'm glad to see a statue of a woman. And I want to just share a statement from Justice Ginsburg that she made in an interview with a publication in New York, and about her time on the bench. And before that, she was a lawyer, had appeared in front of the United States Court herself as an advocate, working with the ACLU. She said, and I'm quoting this from Justice Ginsburg, "I see my advocacy as part of an effort to make the equality principle everything the founders would have wanted it to be if they weren't held back by the society in which they lived, and particularly the shame of slavery. I don't think my efforts would have succeeded had it not been for the women's movement that was reviving in the United States and more or less all over the world at the time." So the statue, she actually got to see a representation of the statue before she died, and she approved it. And her desire was to be shown with a sense of dignity. And when you see the statue, I think you'll agree, it certainly shows the dignity of Justice Ginsburg, and I'm very happy that they are doing this in Brooklyn.
That's great. What a great tribute to her.
Mm-hmm, definitely.
All right. Well, I guess that completes our podcast for today. And until next time,
we'll see you in court.
Thank you for listening to See You in Court, brought to you by the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Please subscribe to this podcast and consider writing a review. You may find related documents to this week's episode on our website, seeyouincourt.podbean.com. Please send any questions, suggestions, or ideas to seeyouincourtpodcast@gmail.com. The producer of this podcast is Raz Misher. We thank Noreen Hassan, Associate Professor and Director of Outreach and Community Engagement of the Georgia Institute of Technology School of Literature, Media, and Communication, and the Georgia Tech students who help bring you this podcast. I'm Fred Smith, Executive Director of the Georgia Civil Justice Foundation. You may learn more about the foundation at fairplay.org. On behalf of Robin Frazier Clark and Lester Tate, until our next episode, we'll see you in court.